Oh. And so, Miss Stanley, if I just get you to unmute.
There we go.
Oh, and looking at my docket here, which case are you here for? Which case are you here for? Please.
Oh, the number?
Whoop, and I can't hear you.
Oh, let me see if I maybe. Can you hear me better now?
I can't hear anything.
I have it unmuted. Let me see.
Is your volume turned down? Okay.
Can you
And is your
can you hear me now?
is your volume maybe turned down?
No, sir. It says it's unmuted.
While you're trying to work on that, I'm going to handle another case. So
Okay.
you think you get it figured out and say something, I'll know you're there. Okay, so which
this is Langley, Shelby and Devin Langley.
Is this one you on the record, Judge?
yes.
Okay, give me 1 second, please.
Already, so it looks like it's served on August 25th. That seems like the right day.
Yeah, so 2021. Judge, if you'd like, would you like me to?
Yeah.
I'm gonna make a copy.
Well, I have that in here. So.
Oh, yeah. Okay. I'll just reference it. Yeah.
About it. Now. So it's a modification.
No, they had. So what had happened? The AG had a child support order.
Okay.
And they never did the divorce, so we needed to do a divorce for them.
Okay.
So this is kind of encompassing the divorce part. We included the same language that's in the AG's for child support.
On a docket sheet, I have fact you're here in May and granted the divorce.
Yes, we just needed to enter. We needed to enter it.
So just an entry.
Yeah, I mean, if you have notes, we already proved it up.
Yeah, that's my show.
Okay, no, that's fine.
I show the divorce was granted back in May.
Okay, well, here's the.
So I'll probably do is right up here that on May 18th, I heard the case and then signed it today. Was he in,
He was in prison.
was he in prison back in May?
Yes, and I think, is he still there? Yeah, we didn't know if he was getting out around that time or not, but
We may just want to put testimony on there, because all I have is that he didn't appear. And I don't remember what, I mean, the notes are that petitioner was present with Anderson, responded, did not appear. And there's a record, and then petitioner was sworn and testified and divorce granted. So, and usually if it was a default, I might say something. So we'll just put it on the record. That's all.
that's fine. Just to make sure we did.
Double protected.
That's fine.
Almost.
Okay.
I'm ready whenever you are.
Right, this is cause number 2021L 7935, in the matter of the marriage of Shelby Langley and Devin Langley. Have everyone else who's here.
John Anderson for Shelby, Lynn Langley.
Right, to raise your hand. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, you may proceed. And before we get started here, I'll take judicial notice that Devin Langley was served on August 25th, 2021, and has not filed an answer.
And Judge, we would ask that you also take judicial notice of the green card that was returned, was certified mail, return receipt requested, and the green card was filed in the case. We'd ask that you take judicial notice of
All right, I'll take judicial notice of that. That's stapled here on the return in the file.
And we'd also ask that you take, on that green card, you take judicial notice that he is in the Clemens unit, was the unit for TDCJ that he was in, which is why it does not reflect his signature. It reflects somebody from the unit signature who was to provide that to him. So we'd ask that you also take judicial notice.
I'll take judicial notice of that also.
All right. Ms. Langley, can you state your name for the record?
Shelby Langley.
And you were married to Devin Langley, is that correct?
Yes.
And as far as you know, Devin is currently incarcerated in Texas Department of Criminal Justice, the Clemens unit. Okay. And y'all had a son, Braden, I think, is that correct? And Braden was born February 13th, 2009. And you're asking that your divorce be upon supportability if it can't go on. And you've also asked for a name change on that, is that correct?
Yes.
That you want to go back to Shelby Lynn Wonky.
Yes.
Is that correct? And that's Shelby with an I.
Yes.
And are you asking the court to approve the default for the possession, access, and child support of the child?
All right, so I'll consider your testimony today and also the testimony back on May 18th, and grant the divorce, approve the property division, approve the terms and support for the child, find that's in the child's best interest, and order your name is changed.
Thanks, Jeff.
All right, thank you. Let me see if they're back here.
Yeah, on the Lopez case, that's a agreed final. Longer, he was sending us a signature page, so
Okay.
as soon as my staff. bring that up,
Okay. I don't know if you have a, oh, maybe she's back. Let's see.
Maybe just leave it open in case or something.
Yeah, probably.
Put it back on there again.
Well, I see her, but now, I mean, I see her name, but
Okay.
I don't see her on here.
So on these exhibits, the ones back there, just destroy them and then just keep the binders.
Okay.
I'm asking.
I mean, and so you have a complete set
Mhm.
back in there, and then we sure don't need two.
But for sure, keep binders.
Yeah,
do the
well, yeah,
binders.
yeah.
Okay. I'll hold off. I'll get them put in the other filing cabinet. Just make sure that the ones I have are complete.
Okay,
But I have them in digital format anyway. And the ones I did not have in digital format, I scanned or more easily.
okay.
So I really think that we're safe too.
Or there's only 3 boxes, just haul them back in that room. At least until
Until we get
the
going on it.
appeals well
Okay.
underway.
I'll
I
get the,
I would hate to think everything's set up and think we have everything and then suddenly, where's exhibit, 777 or something.
okay. Do you want me to, just put them, or just go ahead and put them in the cart? Because those are not necessary to me. So the reason I would want to lock them up is because I need to protect them.
Uh-huh.
Those aren't the official exhibits, so just put them in the box, on the side, stack them up.
Yeah.
Okay. I'm gonna go get the cart from the DA's office, from the county clerk's office.
Okey doke. You ready to go on yours? Or do you need somebody else? Yes, come on up.
And I think they're on that case.
They are.
Good afternoon.
Good afternoon.
Congratulations.
Yes.
Your Honor, this hearing has morphed into something different from what I've had requested. And so what I would like to do, with your permission, is to bring you up to date with where we stand.
This is on Wednesday, right?
This is on Lincoln.
Let me see. Mr. Anderson, you just need me to sign something?
Yes, Judge.
Bring that up, I can sign. So,
All the parties have signed.
that's a little bit.
Yes, sir. Thank you, Judge.
Thank you. Okay, here's what I need. So y'all want to come up and listen or?
Thank you.
Thank you.
Would you?
Hi, I'm Christina Lindsay.
I'm Sarah Hart.
Your Honor, just for clarification's sake, on the underlying motion, which is the motion for your approval or entry of a judgment, an agreed judgment settling claims against me in my role as dependent administrator of the estate, I did serve Mrs. Vincic through the e-file portal, and I also served the 2 children of the decedent by certified mail return receipt requested with a notice of hearing and a copy of the motion for the green cards showing the receipt of service. However, last week in a discussion with Mr. Schiffer, who is the attorney for Ms. Hart, I discussed what I consider to be a jurisdictional flaw in the underlying situation, and that is that I do not believe that the district's court has valid jurisdiction to enter a judgment against me in my capacity as an independent executor under the jurisdictional provisions of the estate code, specifically 32.001 subsection 4
which requires that a suit against an administrator brought in his role as the administrator has got to be brought typically in county court, but in a county where there is a county court at law with concurrent jurisdiction, that you are the proper judge and should be hearing both this case and obviously you have jurisdiction over the estate itself. Mr. Schiffer agreed and yesterday filed with the county clerk here this case, 22 CV 6368, which is plaintiff's an original petition with the identical allegations to the ones made in the district court case.
Okay.
That renders my motion for your entry of a judgment approving my entry of a settlement in the district court case moot. However, we're now in a position where a lot of groundwork has been done in the district court case that we would prefer not to have to repeat for the sake of ease. I had agreed with Mr. Schiffer to accept service, even though it does not accord with the rules of civil procedure regarding service of citation. Christina Lindsay just handed me in the courtroom original citation and a copy of the original petition. I have accepted it. If you'd like, I will enter an appearance here on the record simply to avoid having to delay even further in this case.
And now, should that be in this 6368?
Yes, and that's what it is.
Okay, I don't have that file, I don't think. So I could just put it on the docket sheet. Whoops, yes, I do. So I'll just, I can just write on the docket sheet that you been served.
And I will enter a written answer by general denial sometime within the next 2 days.
Okay.
So essentially what I would like to do and to spend time with you, with your permission, is to clarify two things, which I will, and may I remove these?
Sure.
What I would like to do is to request the court to enter a scheduling order in this cause, whatever I said it was.
So that's 6368.
6368. And to also see whether there is some mechanism by which we could use things like the discovery that has already been completed in the district's court case to have it transferred somehow for use in this case.
Now, is the district court case, is that still an open pending case?
No, it's being dismissed in favor of this one because frankly, Judge Steinhauser lacks jurisdiction to hear.
Yeah, you'd probably, since, I mean, I can't sign an order in a district court case, probably just need to get an order to Judge Steinhauser saying to transfer the pleadings into this case.
Right, well, I don't know under the case authority that I've viewed that he actually had authority to do anything but to dismiss the case that's there, but Mr. Schiffer is filing the dismissal of the district court case since it's his.
Okay.
To begin with. I just feel that there has to be a way to avoid the time and expense.
Oh, sure.
We've exchanged initial disclosures. We've done some requests for production, to which Mr. Schiffer responded, I have presented you for in-camera inspection some documentation, including expert witness reports that go to the potential liability of the real plaintiff defendant in interest in this case. And I would like, without having to go through and spend several $1,000s worth of, to be able to transfer, I believe that it's probably within your discretion once the district court, if we present the files to you and simply ask that you take notice that they were part of the district court case. I don't know the exact mechanism that you would prefer.
Yeah, I guess if I can get that clause number, I can just say I'll take judicial notice of that file and give the clause number.
Okay. Well, I can provide that to you.
Okay.
So that all that being said by way of prelude, we can renotice and reset this within some reasonable time for hearing, but rather than the approval of someone else's motion for an agreed judgment on stipulated facts, what we would ask is that the court simply approve the judgment, since you will be exercising jurisdiction in both cases.
And then have Ms. Lindsay and Ms. Hart, have you seen this judgment?
Are you talking about for Sarah, the plaintiff? Are you talking for Sarah, the judgment for Sarah?
I think
Yes.
that's, yes.
Yes, we have. Yes, Your Honor, yes. Yes, we have.
And I can't directly address Ms. Hart, but she is Mr. Schiffer's client.
Yes.
So essentially, Your Honor, the upshot of it would be, it is my belief, based on my review of the expert reports that have been filed and some meetings I've held with Brittany Cooper, who was one of the other two heirs here, that the facts showing liability are indisputable. It is possible that I could mount, by dint of a fairly costly defense, some challenges to the veracity of the videotapes that were taken of the acts of which the complaint is made. But by my estimation, looking at the reports and analyzing and also discussing with my potential defense attorney, we're looking at approximately $30,000 to $40,000 to vigorously defend this case. I estimate that once I have completed paying capital gains tax on the sale of the property, that there will probably be somewhere in the neighborhood of $50,000 to $60,000 of funds. So from an economic standpoint, given that I do not believe with Mr. Lindsay's passing that it is possible to find other witnesses to be complained of acts and omissions, Ms. Hart would be the main witness in this case, along with experts as to the psychological impact that they've had upon her and the likely cost over the course of a lifetime, which is estimated with a great deal of specificity in the reports that I presented to you on camera, are likely to exceed $500,000 to $700,000 over the course of her lifetime. So for the sake of economy, I would think that authorizing me to enter into the settlement is certainly in the best interest of the state. The fact that I have given notice to both Ms. Cooper and her brother of this hearing and that they did not appear. And I must tell you that I received a call from Austin County State Bank late last week, saying that one of the two checks that I issued to, and it was the one that went to her brother, Taylor Lindsay, which was part of the allowance in lieu of exempt property that you had authorized, was sent to him by certified mail. I did receive the certification card back, and that check has not been negotiated. It was for $3,000. So, I'm not giving testimony at this point, obviously, but I have essentially been told by Ms. Cooper that they want nothing to do with their father's estate. So I do think that they should have the opportunity to say that in open court. So what I would suggest, Your Honor, is that we go through a process, and perhaps early next year, we can reset this for exactly the same hearing that we were set to go on today, which would be your authority for me to enter into that settlement in lieu of trying. I think beyond the money factor, it is obvious to me and to all of the people with whom I've spoken that I have a great deal of difficulty finding other witnesses, since these two folks that are telling me that they had no idea what was going on until a month after their father died. So that finding fact witnesses in defense is going to be very difficult. I have inquired of other people who I thought might know and have nothing upon which I could call someone and ask what was going on.
Were you going to have either Miss Lindsay or Miss Hart give any testimony?
They have, well, in this case, that yes, I was going to ask them to testify regarding their awareness of the impact of this upon their inheritance. But in terms of, I'm being told that there are no facts witnesses other than the complainant herself, the plaintiff herself.
I would say since Miss Lindsay and Miss Hart are here, why don't we just get that testimony and then we can set for another date. And if that can either be the entry, or if you need more, more witnesses, we could just call them that day.
Okay, do you want to go on the record?
You want a record?
Well, I mean, if I'm going to, the thing is, Your Honor, I think that this puts us in an odd posture, because I think Mr. Schiffer really should be here for the type of thing that you suggest, other than, I mean, I can certainly ask some questions to, I don't feel comfortable with questions.
I mean, you anticipate for another day, it's just going to essentially be an entry that will all be agreed.
Well, we have the agreement, but I can circulate the proposed agreements to the other heirs and ask whether they'll.
Maybe see if Mr. Schiffer is.
Ms. Hart is not an heir, since she's not a natural child, which you can see. So the three potential parties affected by the entry of an agreed judgment are Christina Lindsay as one of the potential heirs and mother of the plaintiff.
I'll just call Mr. Schiffer. He's available, and just see if we could.
Yes, Your Honor, I'll call right now.
Okay. And we can just do that today, and then you might not have to come back.
Sure. Is it okay if I call?
Sure.
the, while we're, the other thing will be, I guess, we are going to file a motion to seal the record in this case, 6368 case.
Maybe I'll just check. Yeah, put that in the decree we enter, or if you want a separate order, and then I can put it on the docket sheet also.
Yeah, my reading of the rule tells me we have to notify the Attorney General, blah, blah, blah.
Yes, Judge.
We may need something else on the record.
Okay, I'm on my way back in.
Thank you.
Because we can't reach them at this
Okay. Okay. Or did you want to get any testimony from Miss Lindsay? Just she's here, and we can short circuit the next one a little bit. How long do you think the next one would take?
My anticipation for this one was 30 to 45 minutes. But I would imagine that we could probably knock it out in a half hour.
Okay. Do you have your calendar available? And you can you'll have. Of course, this will be assuming Mr. Schiffer's available too, but
Hello. What do you want me to talk to?
is it what you say? Can you bring this up and just put him on speakerphone? Okay, is this Mr. Schiffer?
Yes, it is.
All right, great. This is Judge Leedy calling from Austin County, and have Ms. Hart, hello, Ms. Hart, Christina Lindsay, and Mr. Sheff here. And so we're kind of working on scheduling the next step. And one of my suggestions, since we have Ms. Lindsay and Ms. Hart here today, and today's going to be kind of an easy day, we could put some of the testimony on today, and that would shorten things up in the future. All right. So you ready?
I'm ready.
Okay. So this is cause number 22 CV 6368, Sarah Hart versus Jerry Sheff, administrator of the estate of Carl Wayne Lindsay. So let me have everybody state their name.
Jerry Sheff, defendant, and dependent administrator of the estate of Carl Wayne Lindsay.
Right.
I'm Sarah Hart.
I'm Christina Lindsay, the mother.
Okay, and then we have Mr. Schiffer is on speakerphone. So Mr. Okay, so Mr. Sheff, do you want to proceed? And I've already taken judicial notice that you're here, you've accepted service, and that you'll be filing an answer later on. But so Mr. Sheff, if you want to go ahead.
Okay, I'm going to call Christina Lindsay.
Yes, sir.
Okay. Would you please state your full name for the record?
Yes, sir. My name is Christina Marie Lindsay.
And Ms. Lindsay, where do you currently reside?
I live in Belleville, Texas.
Okay. And Ms. Lindsay, are you the mother of the complainants in the cause that we're here on, Sarah Hart?
Yes, sir.
Okay. And I'm not going to ask, I'm going to ask you, factually, were you aware of any of the allegations that have been made against the by your daughter prior to the death of your husband?
No, sir.
Were you aware of any of the facts of which the complaint, which brings us here to state?
Was I aware?
Aware of any of those facts before your late husband died?
No, sir.
You are in fact an heir of Mr. Lindsay's estate, are you not?
I'm surviving spouse, yes, sir.
And as such, you would stand to inherit.
Yes, sir.
So my greater concern at this point is the question of whether you are aware that by allowing me to enter into agreed judgment on a stipulated set of facts with Mr. Schiffer, that you will be giving up your right to inherit whatever portion of your husband's estate is remaining after I get finished paying all of his debts.
Yes, sir.
Are you, and I have informed you that the amount of money you might be giving up could be up to $30,000 to $40,000.
Yes, sir.
So you're aware that by authorizing me to enter into the settlement, you are waiving important rights that you would have to inherit from your late husband.
Yes, sir.
Are you willing to do that?
Yes, sir.
Are you aware of the fact that if it is possible that if I were to put on a vigorous defense of this case, the jury might return a verdict that would award your daughter nothing, and you therefore be the inheritor of whatever remained in this estate?
I don't know how to answer that, sir.
Okay.
Jacob, I don't know how to answer that one.
Let me rephrase it. Okay. If I vigorously defend the case, I could win.
Okay.
If I win, you are aware that your daughter would then receive nothing by her suit.
Okay.
If your daughter receives nothing under her suit, is it not true that you would inherit what was left in the estate or a portion of it to which you're entitled as one of his heirs?
Yes, sir.
Okay. So despite that fact, you're willing to allow me to enter into a settlement, knowing that you might, in fact.
Yes, sir. Yes, sir.
I passed away.
Mr. Schiffer, do you have any questions of Ms. Lindsay?
No, Your Honor, no question.
All right, so, Mr. Schiff?
I actually have no questions for Ms. Hart, but if since she's Mr. Schiffer's client, I'll pass her.
Okay, well, since you didn't call her yet, did you want to present anything, Mr. Schiff?
Your Honor, yes, let me put on the record. I have done a factual and legal examination of the issues raised in this suit. Based on that examination, I believe that I have a very low likelihood of success on the merits. And as a result of that, I believe that rather than expending the remaining assets of the estate on a futile defense of a lawsuit in which I can find no fact witnesses to support my potential defense, which is a general denial of the facts which are alleged, that my investigation into the facts has shown that substantial video and audio and photographic records exist of the type of behavior of which Ms. Hart raises complaint. And since I can find no witnesses to offer testimony on behalf of my predecessor in interest, Mr. Lindsay, I am further of the opinion that having interviewed the witnesses and the family members, that there is a potential to create a good deal of trauma by an extended and protracted trial of this matter. One of the heirs has now on the record waived her interest knowingly in her right to inherit. And the others in informal conversation with me and interviews have likely at least voiced an opinion, which I would like to put on record in their voice rather than mine, that they would rather have nothing to do with their father's money. And given the potential expense of engaging the law firm, which you have approved, my retention of another law firm to defend me, their costs are estimated to run between $30,000 to $40,000 for a vigorous defense, which would include extensive paper investigation and the retention of experts to go over the information which is provided by the expert opinion and in the reports that Mr. Schiffer has provided, and to depose Ms. Hart and the other potential fact witnesses in the case, which would be Mrs. Lindsay as a co-householder, to look more deeply into the relationship. But given all of those factors, that it is in the best interest of the estate, in my opinion, to enter into the settlement.
Mr. Schiffer, anything you want to ask Mr. Chef?
No, sir, I think that Mr. Chef summed it up perfectly.
Okay, very good then. Mr. Chef, do you have anything else?
I really don't, Your Honor.
All right, so Mr. Schiffer, did you want to get any testimony today from Ms. Hart?
No, Your Honor.
Okay. All right. So I'll consider all that testimony, and then do we need just to get another date to complete the hearing?
I believe we do, so that I can give sufficient notice again to Ms. Lindsay and Ms. Taylor of their rights to come forward and complain about my entry into a settlement. If I may, direct to Mr. Schiffer, Jacob, I have requested the court to enter a scheduling order in the case just in case. Do you have any objection to that?
No, just in case.
Just in case they come into court, there is testimony on the record that disinclines the judge to authorize me to enter into the settlement with you at the next hearing.
Yeah, no, I have no issue with that. No issue at all. I guess actually, Your Honor, if I was to ask, if I was to get Ms. Hart on the record, there is one thing I'd like to get on the record.
Okay.
If I can get her.
Why don't you go ahead? So if you raise your right hand, you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do not.
Okay, so Mr. Schiffer, you may proceed.
Thank you, Your Honor. Ms. Hart, can you please state your name for the record?
Sarah Alexandra Hart.
And you've read the facts in the complaint that is the basis of this case, correct?
Yes, sir.
And are those facts
Yes.
true
Yes,
and
sir.
accurate?
Yes, sir.
Okay. No further questions, Your Honor.
Mr. Chef, anything for Ms. Hart?
I have
Okay, so we'll go off the record and we'll get with the coordinator and find a date that everybody can be here for the next hearing.
And real second, Jacob, look off the record. I just honestly don't recall Ms. Lindsay being sworn in for her testimony. Just going down.
Okay. Be on the safe side then. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay. All right. So we'll go off the record and we think,
Yes, sir.
all right, we need to find a date, probably about 30 minutes or so, and you're looking at early January, mid-January.
Yeah,
Early January.
early mid-January would be fine with me.
Me as well.
We have January 4th in the morning.
How's that? January 4th at 9 o'clock.
Works for me, Your Honor.
Mr. Chef's checking his,
This would take a moment.
And to confirm, Your Honor, this is the hearing for the motion on agreed statement of facts?
yes.
Okay,
That works for me as well.
All right, so then we'll set that for January 4th, 2023 at 9 o'clock. And then so, Mr. Jeff, then you'll notify the other heirs and let them know, see if they want to show up or not.
I will be on it. And in light of that, I think,
Okay, so Maria, if you want to put that down, January 4th at 9 o'clock, that's number, it's 22 CV 6368.
Okay, I'll go ahead and put it down on the system.
Okay, thank you.
You're welcome.
All right, so I think is that all you want to do today? And Mr. Schiffer, do you have anything else for today?
no, Your Honor, and I wanted to thank y'all for calling me. I didn't know that Sarah was gonna be there today. I know that the goal was to drop off the petition and citation, but I'm glad we got to do this, and it's a pleasure to meet you. I'm sorry I wasn't there in person.
No problem. Okay, real good. Thank you.
Thank you.
Okay, so you can get your phone back. And so probably should have done it while I was still on the phone, but just if you want to just tell Miss Lindsay and Miss Hart then what we're going to do on January 4th, so they'll know what's going to happen next.